All rise. Please take your seats. Please take your seats.
Good morning, ladies and gentlemen. Can I have the appearances?
May it please this honorable court. My name is Cara Schillenfred, and I represent the appellant Mariette Warrington in this matter.
Thank you.
May it please this honorable court. My name is Heather Felix Evans. I'm led by Mr. Roger Ford QC, and we represent the respondents in this matter.
Right, thank you. I believe you've been circulated with the judgment already. You'll see that it is a unanimous judgment. President Saunders and Justice Witt concur in it, but are unable to be present this morning. I will, however, call upon Justice Barrow to deliver the judgment summary.
Thank you, President. At the root of this dispute is the issue whether the appointment of the appellant, Ms. Warrington, as the general manager of the respondent, the Dominica Broadcasting Corporation, was valid. The High Court and Court of Appeal decided it was not valid because the board of the corporation did not obtain the advice of the Prime Minister to appoint her as required by the Dominica Broadcasting Corporation Act. Ms. Warrington's employment history with the corporation started in 1993 when she was first appointed as a sale director, and later she was employed under 2 consecutive employment contracts as the general manager and accountant. The second contract, which commenced in 2004, ended in 2008. That's referred to as the 2004 contract. Before the end of the 2004 contract, the board took the unanimous decision to reappoint Ms. Warrington, although it never directly told her so. After the 2004 contract had ended, Ms. Warrington kept on performing the duties of the general manager and accountant. Having performed for some 15 months as such, Ms. Warrington received a letter in March 2010 informing her that she was on a month-to-month contract and she was terminated in the subsequent month. During the period that she was employed, she continued to receive the same salary and allowance as under the 2004 contract. In determining whether the corporation had validly appointed Ms. Warrington, the CCJ considered whether the board had received the Prime Minister's advice, as was required by Section 6, subsection 6B of the Broadcasting Corporation Act, which requires the corporation's board to act on the advice of the Prime Minister in appointing its managers. The evidence given at trial by the parties reflected their conflicting positions. The court noted that while mention was made of the conflicting evidence in the courts below, there had been no discussion of what constituted the advice of the Prime Minister. In interpreting the expression, the court found it was not used in any technical or specialized way. The expression simply referred to a communication or indication from the Prime Minister. As such, in its context, there was no requirement for the Prime Minister to find the candidate. The board identified the candidates, and it was for the Prime Minister to communicate whether he approved or accepted a candidate. The court also found that while the courts below had not regarded as significant the commonly established fact that the board met on 17 February 2009 with the Prime Minister and discussed, quote, the matter, unquote, of Ms. Warrington's appointment, the meeting was significant in the context of the case, because it led to a number of conclusions. Firstly, the Prime Minister knew that Ms. Warrington had been the General Manager of the corporation for a number of years. Secondly, he knew that she was currently functioning as such General Manager. Thirdly, he knew that the board had kept Ms. Warrington in the position while they awaited his approval of the grant of a new contract to her, as it had been discussed at the meeting. Fourthly, the Prime Minister stated in the meeting he would await formal communication on the matter of Ms. Warrington's appointment. Fifthly, the inference from the preceding facts and the board minutes generally is that the Prime Minister approved of and acquiesced in Ms. Warrington's engagement as General Manager, if not the length after the expiry of her 2004 contract. Sixthly, it is a certain inference that if he had not approved, Ms. Warrington would not have remained employed as General Manager with the corporation. These conclusions are bolstered by the minutes of the board, which show that what had engaged the board and Prime Minister was not Ms. Warrington's selection as General Manager, but the length of her contract. The court found that it was most revealing that neither the board nor the minister mentioned asking for the Prime Minister's advice on the selection of Ms. Warrington as manager, which raised the inference that the Prime Minister's approval was a known fact and not a mere assumption. In those circumstances, the court held that there could be little doubt that the Prime Minister had communicated his acceptance of Ms. Warrington's appointment by the board, even though the board had not settled on the period of engagement. The court also decided that the law permitted the Prime Minister's advice to be given retroactively, so it did not have to be given before the reappointment occurred. The court then examined the corporation's submission that the requirement in Section 66B for the Prime Minister's advice to be given created a condition precedent to the existence of any contract appointing a general manager. Although the court's finding that the advice could validly be given retroactively rendered this argument ineffective, it considered that its success in the lower courts suggested this court should offer some analysis. The court observed that there was no discussion of what made obtaining the advice a condition precedent so that the failure to obtain it rendered the appointment void, pointing out that not every failure to satisfy a requirement results in an invalid exercise of power. In the court's view, to decide whether invalidity was a consequence of non-compliance, Parliament's intention had to be considered. To do so, the court examined the provisions of the Broadcasting Act, particularly the roles of the Broadcasting Board, the Minister responsible for broadcasting services, and the Prime Minister. The court regarded it as significant that the Minister, not the Prime Minister, was tasked with the functional management of the corporation. The Prime Minister had the very limited role of advising on the appointment of senior staff. In the court's view, a failure to obtain this advice could only ever amount to a mere technicality that would easily and simply be corrected or acquiesced in. The court then considered the effect of noncompliance, firstly pointing out that the traditional approach, which created a distinction between directory and mandatory requirements, was no longer regarded as helpful. Instead, it held that the correct modern approach to procedural requirements is for the courts to focus not on the literal classification, but rather on what should be the legal consequence of noncompliance with a statutory or regulatory provision. Using the modern approach, the court found that it was unlikely that Parliament intended that a failure to obtain the advice of the Prime Minister to renew an appointment should result in its invalidity if no purpose would be served by the consequence of invalidity. In the instant matter, the Prime Minister had accepted that Ms. Warrington continued to perform as General Manager, particularly given the 17th February 2009 meeting. As such, his approval and acquiescence amounted to him having advised on the appointment. The court then considered the terms of the employment, starting with duration. The court compared the Industrial Relations Act 1971 in England with the Labour Contracts Act in Dominica and found that the Dominica Act went far beyond the scope of its English counterpart by imposing a contract on employers when they failed to comply with their statutory obligation to provide a written contract to employees. The court disagreed with the Court of Appeal that the Labour Contracts Act did not apply because the Broadcasting Act made specific provision for the advice of the Prime Minister to be obtained before a contract could be created. After examining the Act, the court held that the Act provided protection for employees as it ensured that employees had the benefit of a written contract. When the board failed to satisfy its internal procedures, which in this case was the advice of the Prime Minister, the Act overrode and made nugatory the board's further failure to provide a written contract to Ms. Warrington. The court also rejected the corporation's argument that the terms of the former contract did not operate because the board did not intend the fixed term provision to apply. The court held that the corporation could not escape the legislative insistence that there must be a contract and the imposition of terms of a contract upon an employer. Therefore, the court concluded that by operation of law, Ms. Warrington was employed following the expiration of the 2004 contract on the same terms as her former contract. In particular, she was employed on a contract for 5 years, from 1st January 2009 to 31st December 2013, and pursuant to which either party could terminate on giving 6 months' notice or paying 6 months' salary in lieu of notice. The court then considered Ms. Warrington's entitlements arising from termination. The court held that by wrongfully terminating Ms. Warrington's employment, the corporation was liable to pay to Ms. Warrington damages for breach of contract. Damages in this case meant the total sum she would have received had the termination been done in accordance with the terms of the contract. On that basis, the court found that Ms. Warrington was entitled to the 6 months' salary in lieu of notice, which the former contract had fixed as liquidated damages, and the specified gratuity payment of 20% of the salary paid during the period of engagement. Based on Clause 6 of the contract, she would have also been entitled to an award of damages as compensation for the salary lost for the remaining period of the contract. The court held that this provision did not simply entitle Ms. Warrington to receive the equivalent of her salary for the remaining period of her contract, but required her to prove her loss. The court found she had not provided evidence of loss and there was no basis for deciding she was entitled to any amount of compensation. Consequently, no award was made to Ms. Warrington beyond the amounts due for 6 months' salary in lieu of notice, gratuity for the period of engagement, and balance of accrued leave, which amount to $52,300 EC dollars. In a concurring opinion, the President of the Court, the Honorable Mr. Justice Saunders, took the view that even if there had been a failure to comply with the statutory requirement that the Prime Minister should advise on the appointment of the manager, the law must be premised on principle and must also make sense. It would be unreal to suppose that after the expiration of the 2004 contract, there was no employment arrangement in existence between Ms. Warrington and the board. Ms. Warrington had dutifully carried out the functions of general manager with the knowledge of the board, and if either party desired to end that relationship, notice had to be given. It was quite inappropriate for the board unilaterally and belatedly to seek to impose a 1-month notice period. Apart from its inappropriateness, that period was unreasonably short. Accordingly, the court allowed the appeal and awarded interest on the sum awarded at the statutory rate of 5% per annum from the date of the judgment in the High Court until payment. The court also awarded basic costs of $37,800 together with disbursements to be assessed by the registrar, if not agreed, and prescribed costs of the claim based on the sum now awarded in the High Court and the Court of Appeal. The award of costs of the counterclaim was left undisturbed.
Right, so that was the basis of the judgment in favor of the appellant, Ms. Warrington. Do counsel have
Much obliged.
any to raise?
Much obliged.
Okay.
Much
Much
obliged.
obliged.
What rise?